for our annual children's vacation. This year, we are going to Orlando, Florida. Experience the thrills, the fun, the rides, the feasts, and much more. Some of the excitement includes visits to Disney World, SeaWorld, Aquatica, the Holy Land Experience, the Florida Science Museum, and the zoo. Dates for this amazing vacation are July 11th through the 17th, 2021. Our lodgings are at the exquisite Westgate Vacation Villa. Individual, family, and group registrations are available. If you'd like to sponsor a child who may not have access to a vacation this summer, you can do so. For more information, please call 832-338-7460. Again, 832-338-7460. This event promises to be one of the best vacations ever. The law office of Ope Badaru is a full-service immigration law firm based in Houston, Texas. We provide a full range of immigration services, from temporary visa applications to permanent residency and citizenship. All our services are structured and tailored to meet your unique needs and take the stress out of the immigration process. For more information, please call 346-888-7091 or visit our website at www.opebadaraulaw.com or email at info@opebadaraulaw.com.
Effective and efficient leadership is undoubtedly one of the greatest areas of need in church today, and that's where we come in. The Redeemer's Leadership Institute has been developing Christian leaders capable of taking the church forward into the 21st century since 2008. We specialize in these 6 areas: the training of pastors for new and or smaller parishes, the training of leaders to train other leaders, the training of leaders to adapt to a changing world, the training of potential leaders in order to equip them for leadership roles, the training of new pastors on their societal, governmental, and business issues impacting their church activities, the training of leaders to have a balanced spiritual and secular pursuit. Our staff include highly qualified and experienced teachers and trainers who are passionate about building up the next generation. This is all towards a goal, that the man of God may be perfect, thoroughly furnished unto all good works. 2 Timothy chapter 3, verse 17. Please visit our website, www.redeemersleadershipinstitute.org, to register for your next class.
The King's Justice Ministry is a not-for-profit outreach arm of the Redeemed Christian Church of God, the King's Palace, Katy, Texas, with the mission to create political reawakening and to provide legal and social services to our community in several areas, especially immigration services. As citizens yearn for good governance, law, and justice in the world today, the King's Justice Ministry has, in the past 4 years, strove to create political reawakening, connect with the defenseless, and support the vulnerable in our society. We specialize in these 4 areas: immigration services, governance and politics, domestic abuse, and prison outreach. We strive to make a difference in our community through several outreach programs, including our monthly immigration clinic, prison outreaches, voter registration awareness and engagement, and domestic abuse awareness. To find out more about the King's Justice Ministry, please visit www.kingsjustice.org.
Good morning. Thank you for joining us. My name is Ayoade Adekombi, and we are welcome to the King Justice Ministry Immigration Symposium. We are glad you could join us, whether you are watching us from the United States, watching us from Africa, from Europe, from Asia. We are glad you are here with us. And today, one of the things we are planning to achieve is to provide information about immigration and some of the questions that you might have about the recent immigration issues in America. Our attorneys are legal professionals. They are ready to provide that answer to the questions that you might have. Again, thank you for joining us. We are glad you are here with us. And I would like to start by first appreciating our partners, those who have collaborated with us to put this program together. First, I would like to appreciate the Redeemed Christian Church of God, Kings Palace, Katy, Texas, especially our pastor, Pastor Tunde Badru, and Pastor Mrs. Shade Badru, for giving us this opportunity or giving us a platform to host this event. And also, I would also like to appreciate the Redeemers Learning Institute for being our partners. And then I would like to appreciate all our attorneys, all the law firms that have decided to work with us to bring this event to you. So with me today is my co-anchor, Dr. Okpe Badaru. She's also a legal attorney. Dr. Okpe Badaru has over 18 years of law practice in multiple jurisdictions, background in international human rights and professional experience working in the field of immigration. She's an immigration attorney as well. She's a licensed attorney in the state of New York, the United States District Court, and Northern District of Texas as well. So please join me in welcoming Dr. Okpe Badaru.
Thank you for having me. It's great to be here.
Okay. And then in addition to Dr. Okpebadu, who is co-anchoring with me today, we have 3 immigration attorneys that are going to be joining us as well. First on the list is Attorney Busayo Fasidi. Attorney Busayo Fasidi, she has practiced, she's a practice attorney as well. She's an immigration attorney within the Houston area for 13 years. She's been practicing. She's licensed in the United States, in Texas and in the state of New York. She has an LLM degree from the University of Houston Law Center and a Bachelor's of Law from the University of Ibadan in Nigeria. Please welcome Attorney Busayo Fasidi to our panel. And then I also have Attorney Uche Nwaneri. Attorney Uche Nwaneri began her career by bagging a bachelor's degree from the University of Nigeria. That's in Nsukka, and then she became a barrister and solicitor of the Supreme Court of Nigeria. After immigrating to the United States, she bagged a master's in management from St. Mary's University in the state of Minnesota. She has a Juris Doctor degree from William Mitchell College of Law, now Mitchell Hamlin School of Law in the state of Minnesota. And then with her also is Attorney Chinedu Nwaneri, is licensed to practice law in Nigeria as well, and the United States of America, the state of Minnesota. He holds a Juris Doctor degree in law from the William Mitchell College of Law, now Mitchell Hamlin School of Law, St. Paul, Minnesota. He has a Bachelor of Law he obtained his Bachelor of Law from the University of Nigeria. He has successfully handled legal matters before several state and federal courts in the United States. Please join me in welcoming all our attorneys, Attorney Busayo Fasidi, Attorney Uche Nwaneri, and Attorney Chinedu Nwaneri. You'll be hearing more from them as we proceed or progress from the program. And then I am a member of the King Justice Ministry Board. And as a member of the King Justice Ministry Board, I'm also a college professor here in the city of Houston, one of the community colleges. I teach political science. So as we progress in the program, you'll be hearing more about our experience and practices. And then one of the things, again, that we hope to achieve today is to answer some of your questions. So if you are watching us on Facebook, on YouTube, on Twitter, on Instagram, please drop your question in the comment section. We have people who are monitoring those platforms. They will get the question across to us so we can ask our attorneys. Hopefully, we hope to be able to answer some of your questions. And then if there are questions that are unanswered that we may not be able to answer because of time, you can reach us. Our website is available. Then you can go to kingjustice.org or reach any of our attorneys as they provide their information. So I would like to hand over now to my co-anchor, Dr. Okwe Badaro.
Thank you very much, Mr. Adekombi. Like I said, like you said, this forum is for us to have a discussion about the current reforms and also give you some information about immigration generally to the United States. I would like to start by asking Attorney Bushayo Fasidi some questions. Attorney Fasidi, let's start, before we talk about the reforms, can you just enlighten us, for example, about the student visas in the US? What options are available to students after they gain their technical skills, after their education? What options are available? And give us a little bit about student visas.
Thank you so much for having me today. I'm glad to be a part of this program. So for student visas in the United States, there are actually two ways. These are visas that allow individuals to enter the United States temporarily to attend schools. We need to bear in mind that student visas is not just for college students, because I think we have that misconception. We have student visas for those who are attending to maybe enroll in a seminary. We have student visas for elementary students. Yes, we have student visas for elementary students and also for high school students. So the purpose of the student visa is for us to be able to, or for an individual to be able to attend school legally within the United States. The B2 visa, which is the visitor's visa, is not the appropriate visa for use when you're entering the United States for the reason of attending school. The appropriate visa is the student visa, and it can be obtained in two ways. Either you obtain it at your consulate abroad outside of the United States, and if you're within the United States, you have the option or the opportunity to change your status from whatever prior status you might be in, which is the most commonly one is the B1, B2, which is the temporary visitors. You are able to change from that to the student visa while in the United States. But with the student visas, you can't enter the United States until 30 days prior to the start of your program. And the same applies for those who are changing status within the United States. You have to remain in valid status until at least 30 days before the program starts. And just on a practical note, this is taking a while, like especially for those who are within. The fastest way is to apply abroad. But I know some people might be here visiting on a temporary visa, and then they change their mind during the course of their stay, and they decide to apply for the student visas. So while they are here, it could take a while. Like in my own practice, I've noticed that it takes a year or more, about 12. Then with the past COVID, it's taking a while. So you have to, during the time that you're waiting for your student visa application to be adjudicated, you must remain in valid status, which means that you have to keep extending your stay. So that said, there are two types of, the student visa could either be the F visa, which is for academic students, or it could be the M visa, which is for vocational students. Vocational students, maybe you're here to learn a trade. I also want to briefly touch on the J visas, because these are visas that we hardly use. They are for exchange visitors to the United States. So let's say you're a research professor, research assistant, or even a student, and you want to come temporarily just for you to learn some more about your trade or carry on research. Then there's also the J visa for teachers. If you're a certified teacher in your country of origin, you are allowed to come into the country on the J visa. There's the best, if you need more information, go on the USCIS website, make sure it's the government website. Then, that would give you an idea of whether or not, and the institutions that you can attend, for your J visas. So on the part of the optional of the work, we have what is called the optional training program. So this allows anyone who is on a student visa to work temporarily or to apply the skills they gained in their course of study while they were on the student visa for about a year after they complete their process. But we also have the pre-completion OPT. So the pre-completion OPT allows you to work once you've completed at least one full academic year of your program. You can apply for the pre-completion OPT, and you're allowed to work for about 20 hours a week. with the pre-completion OPT. But the post-completion OPT, you can work for about a year. And then if you're in maybe like an engineering course or a science-related course, you have the option of extending that for another 12 months, making in total about 24 months. Thank you.
Thank you very much. Thank you very much. Another thing I would like you to shed light on is the difference between the fiancé visa versus the green card, and what should a person consider when they're choosing one option over the other?
Okay. So the sole main reason for the fiancé visa is to bring in your fiancé. The fiancé visa is for fiancés. Fiancé is anybody you're engaged to get married to. So it's to help you bring your fiancé from outside the country into the United States for the two of you to get married within the United States. And usually you're given 90 days from the entry of that person to get married. So the fiancé visa is not to bring in your spouse, it is to bring in your fiancé. So one thing I want to highlight here is, especially for those of us who are from countries like Nigeria, we recognize customary marriages. So, and customary marriage is a valid form of marriage under the Nigerian culture. So if you've engaged in customary marriage and you now present a fiancé visa application, that could pose a problem, because the consulates, they are aware of our cultural practices, and they know that the traditional marriage is valid under the Nigerian law. So, but if you're not yet married, or if you just do maybe like an introduction, that's not considered a marriage. But if you're not yet married, you're able, as a US citizen, you have the right to bring in your fiancé from their country of origin into the United States, and then the two of you get married within the 90-day period and apply for the green card. So the fiancé visa is actually a temporary type of visa, whereas the green card is a permanent resident visa or card or status. So the first step in the process is to bring in the person on the fiancé visa. And then afterwards, your fiancé, who has then become your spouse, will have the opportunity to adjust their status within the United States to that of a permanent resident. So that is where the differences come in. So there's also, like, for people who, let's assume you married already, you started the immigration consular process. And it's taking, there's some delays in the process. You can actually file a K3 visa. The K3 visa is very similar in nature to the K1 visa, which is for the fiancé. So the K3 visa allows your spouse to enter the United States, so that way they can await the processing of the application which has been filed, the relative application which has been filed for them by you. So those are the differences. We have to be one thing I want to highlight here, based on my practical experience, is that sometimes we feel that maybe, you're married, but you now think maybe the fiancé visa is a faster way of bringing in your relative into your spouse into the United States. It doesn't work that way. It's not fast. It's not faster. What I'm experiencing is that they both take about the same length of time in actual processing. So, and then whenever you present yourself or you present your case at the embassy or before any US government official, that has the power or jurisdiction to adjudicate these cases, you're under the law of perjury. So you have to be very mindful of how you present your case, because you don't want there to be any misrepresentation. So if you've been married, it's not going to be faster if you file for the fiancé visa. There's no, the I-130, which is the relative petition, is going to, it takes about the same length of time. So you might as well go ahead and file the correct visa for your spouse to enter the United States with.
Thank you. That was very informative. Another issue that we come across is adoption. Can you please enlighten us about adoption? Who is eligible to be adopted? And what are the implications of terminating parental rights when you are considering adoption of a child?
Okay. Thank you for that question. So when it comes to the issue of adoption, anybody, I'm speaking now as with my knowledge of family law, like in Texas, you can adopt anybody. You can adopt an adult. You can adopt a child. So anybody can be adopted. So, but the thing when it comes to immigration, if you're going to be adopting a person, the adoption process must have been finalized. Not that you filed a case in court, no. It must have been finalized, that the judge must have issued a final adoption decree or granted the final adoption, or you must have met the final legal requirements for the adoption before the child turns 16, not a day later, before the child turns 16. So, but they now give an exception to those who are adopted. Maybe if you adopt siblings of the child that you previously adopted. So they extend the year to 18. So let's assume you've adopted a child prior to the child's 16th birthday, then you decide to adopt the child's other siblings, then you can do so, by the 18th birthday of those children. So that is adoption in relation to immigration. So what we also need to understand is that adoption is final. Like adoption is not, you can't adopt a child then, or maybe let's assume you give your child up for adoption, then take the child back. No, it's final. And for immigration purposes, if your child gained immigration status through adoption, you will not be able to gain any benefits whatsoever from that child. And in my recent practice, I noticed that even with adoption, you have to show that adoption was not just for immigration purposes. The way it's adjudicated is actually adjudicated in the same way of marriage applications. That is how there's actually a case, a precedent case on that. So when they are considering adoption applications for processing, they view it the same way as they view marital petitions, which one of the other attorneys is going to discuss in detail. Marital petitions for processing. So with the adoption as well, the adoption mustn't have been it mustn't have been for immigration, solely for immigration purposes. It must have been as a result of, it must have been genuine or legitimate. And then there are three main processes. We have the Hague process. These are people who, these are countries who are privy to the Hague Adoption Convention. Then we have the non-Hague process and we have the immediate relative process. I'm going to dwell more on the immediate relative process because that is what affects our community the most. Most of us are not from countries that have to do with the Hague process. So the immediate relative process allows you to bring your adopted child in as an immediate relative of a United States citizen. So once one of the things that you have to prove when you're bringing your child in is that you've spent at least 2 years with your child. Mm-hmm. So the 2 years with your child might have been prior to the adoption. So let's assume you had a child living with you before you immigrated to the United States. And the child might have been with you right from when they were born, but even the adoption didn't take place until much later. That's still fine, as long as you have proper documentation to prove that the child lived with you for at least two years, because the child must have been within your physical control, parental control. So, that's like the main thing, because that's one of the areas where I see the problems with. Most of the times, the adoption must have been done before the child's 16th birthday. Then we have documents to show that the adoption was valid, but the 2-year requirement, it has to have, it must have happened. So that's where one area that I find that a lot of people have challenges, because it can't be based on just visits, like random visits to the country to see the child. No, the child must have been under your parental influence and control for the 2 years. Then another issue I want to raise is between adoption of family members. Mm-hmm. Sometimes it's very difficult to prove those cases that you didn't adopt the child just for immigration purposes. But what the USCIS wants to see is that even if the parent, let's assume they're nearby or they want to know that you were the one that exercised the parental control over the child during that period of time, or even going forward from the adoption process, that you were the parents, you were the one who was in control. The family member who was the biological parent of the child did not have any say in how the child was guided. So
thank you. Thank you so much. That was very informative. Could you please tell us about the International Entrepreneur Program? It's something we've heard about, and I think we will need, some enlightenment about that.
Okay, so the International Entrepreneur, parole, there's this, how will I put this? There's the opportunity to enter the United States on a temporary basis on parole. Mm-hmm. So parole allows you to come in for a specific purpose. There are some people who come in with parole, maybe to obtain medical treatment, or maybe their family member is at the end of their life and they just need, it's kind of bypasses the usual consular application for visa process. So the USCIS established what they call the International Entrepreneur Parole. So this allows an entrepreneur is somebody, a business owner, to come into the United States to conduct business activities for a certain time. And let's assume you have you run your business outside the country, and you now decide to establish a subdivision of your business within the United States. You can use that to come in and for you to work temporarily solely for your own particular business. So in 2018, the previous administration filed a proposed rule to withdraw this International Entrepreneur Parole Program from the Department of Homeland Security. But recently, on the 11th of May, about a couple of days back, they decided to withdraw their proposed rule. So that the International Entrepreneur Parole is now in force. And you can find more information on the USCIS website. But the basic thing is that you have to prove that you have substantial ownership interest in the startup entity that was created within the 5 years in the United States. And that entity has potential for rapid growth and job creation. The whole essence of this program is that the United States is going to have some type of benefit, economic benefit, by your program or by your business. Then you have to show that the central and active role in your startup is for you to assist with the growth and the success of the business. And then I already mentioned it that it's for the benefit of the United, that's going to provide significant benefits for the United States. Then your spouse and your child can also apply with you for parole under this new rule as well. They also they qualify as well, and they're eligible to apply with you. But the only thing is that when they come in, they are allowed to work. So your wife, let's assume your spouse enters the United States with you on this, they can apply for a work authorization. They're not mandated to work for your startup as you would be.
Thank you very much. That was a very informative session. So I want us to go back and start talking about the current reforms. And in this way, I will be speaking and asking questions from Mr. Adekombi and Attorney Uche Nwaneri. So when we talk about the current reforms, we've heard a lot about what the Biden administration is doing, but it will be good for people to have a little bit of background about the US lawmaking process. So Mr. Adekombi, can you please give us a brief analysis of federal lawmaking process in the United States?
Yeah, thank you. Basically, one of the things we tend to have this notion or assumption about when announcements are made about laws, everybody usually believes that law automatically comes into effect. There are rationales that people that make laws, they give that they are trying to address a problem. So they don't just make laws. Everybody acknowledge that there is an immigration problem in America. So when the new administration was sworn in, one of the things the president did is to say, okay, we are going to introduce a new immigration law, but it has not yet become a law though. It has to go through a process. So that's one of the reasons why we are hosting this symposium. So people don't have this misconceived opinion or notion about whether the law is already, no, it has not become law. So what has to happen for this bill or proposal to become law? First, the bill has to go to the United States Congress. When I say Congress, I mean both the US Senate and the United States House of Representatives. So when it gets to Congress, Congress has to do what I call committee meetings. They have to take it. It might be 6 months. It might take about a year. It might be something that is quicker or faster. It depends. However, like I said, it is a process, and that process doesn't just begin by president making pronouncement. That process begins with the president submitting a proposal to the United States Congress. The Congress have to work on it. Now they have to reach an agreement on the content of the bill, both the House and the Senate. After they agree, they have a vote on the bill. Then after the bill has been passed in both the House and the Senate, it is still not yet a law. It has to go back to the president, and the president is going to append his signature. So the Immigration Act, as proposed right now by this current administration, is not yet a law. It has passed the House of Representatives, yes, but it needs to, now they have to take it to the Senate of the United States. Now the Senate has to approve, and to approve they need 60 votes. Right now, Democrats have 50, Republicans have 50. So they need 10 on both sides for it to become law. So if that happens, then that bill becomes an act of Congress. Then it goes to the president signs it, and then it becomes law. And then in America, there are different rules. The bill or the law doesn't come into effect immediately also. They have to give about 60 days or 90 days, depending on what type of bill, before it becomes law. So hopefully, so the whole essence of what I'm trying to say is, hopefully the Senate and the House and the president do what they have to do for the bill to become law. But as at this moment, nothing has changed as relating to the immigration law in America. There are a few rules that have changed, but not a major structural change as regards immigration.
Thank you, Mr. Adekombi. Thank you for that background. And based on that now we know that the laws are still in the works. There may have been some policies change. I would like to invite Attorney Uche Nwaneri to please tell us some of the important immigration legislation that are currently moving through the Congress, and then highlight for us what is being proposed in the bills, and then please compare their proposals, because we hear a lot. There's American Dream Act, there's US Citizenship Act. Please shed some light and let us know which are the current important legislation that are moving through Congress right now.
Thank you, Dr. Badaru. Nice to be here. And I will dive in immediately to the reforms. So before I start, I'm going to explain what the bills are. When you hear a bill, it starts with HR, then that means it's from the House of Representatives. And then when it starts with an S, it's from the Senate. And thank you, Mr. Adekambi, for that brief introduction or background. So with that, I'm going to give you insights about the bills, especially the immigration bills, those ones that pertain to the immigration reform, as well as where we are with those bills. There really is a lot of misconception out there, and I'm not going to lie to you. I've had clients who have told me, you know what, I really want to be undocumented at this time so that I can benefit from this bill. And I said, no, this is really not the time. So I'm glad that we have this opportunity to educate the public about what this is. So I am going to, we have 4 bills in total. Okay, and the first bill is the United States Citizenship Act, and it's HR 1177. So this will tell you it is from the House of Representatives. And one important fact I want to tell you about all these bills, they're all geared towards making people who are here in the United States, who entered here lawfully and maybe have overstayed their visa terms and are now undocumented or illegal, people who entered in illegally. The whole purpose is one, and that is for an earned path to citizenship. That is the objective of most of these bills. So I know you have read a lot about what it contains and where we're going. But like I said, with the Biden administration, there's a lot of hope, but we have to be patient, and that's why I'm here to let you know where we are with these bills, and that way you can ascertain to know what next actions you can take. So the United States Citizenship Act, the HR 1177, it was introduced on February 18, 2021, and it was introduced by the Democrats. Now we have 141 co-sponsors, which are all Democrats. So this bill has not yet been submitted to the committee. So because it's not been submitted to the committee, we can't even talk about votes in the House of Representatives or the Senate or even going to the president. So it's still at the inception. It was just introduced. Now this bill, it's the one that, yes, you're going to ask, who is it for? It's for non-citizens, and it's going to cover their spouses and children. And for you to benefit from this bill, you have to have been physically and continuously present in the United States. But one thing, again, I'm going to tell you about this bill is, in order for you to benefit from it whenever it gets passed, is that you have to be on the good side of the law. You don't have to, and I mean, you shouldn't have committed felonies, any felony offense, or at least 3 misdemeanors. You would have paid all your federal taxes. So in anticipation of when this bill will be passed, it's good that you're on the good side of the law when this bill will be passed, and this you can be doing in anticipation. So the next bill is the HR 6. That's the Dream Act, Dream Act and Promise Act. These are 2 bills in one. And this started from, like I said, HR, that's the House of Representatives. It was introduced by Democrats on March 3rd of 2021. And it was co-sponsored by 175 Democrats. It has passed the House. It passed on March 18 of 2021 and has been sent to the Senate. The Senate has yet to pass any vote yet. Excuse me. The next bill is the Dream Act, S-264. It's still the same kind of bill with the previous one I mentioned, the Dream Act and Promise Act. But this is from the Senate. This is their own version. That's this S-264. And the S-264 was introduced by a Democrat, and this time was co-sponsored by a Republican, which is good. So it got introduced on February 4th of 2021. It has not yet been submitted before the committee. Therefore, we're not even talking about any votes yet. So you'll know that the one before by the House of Representatives is even faster because we're just waiting for the votes from the Senate. Now, the other bill is the Farm Workforce Act, HR 1603. This was also introduced by Democrats, and there are 48 Democratic co-sponsors. And interestingly, there are 13 Republicans. So this is really good. We, for all purposes, would want to see we want to see both houses or both parties involved in the bill, in the legislation. So with this, it passed the House on March 8 of 2021 in the House and has now been sent to the Senate. So I guess this is really good. And then we have the Citizenship for Essential Workers Act, that is S-747. It was introduced by Democrats, and now we have the committee meeting. The committee meeting was actually held on 5/12 of 2021, actually this week. That's interesting. So it's yet to be passed by the Senate. It's yet to be passed by the House of Representatives and, of course, the president before it becomes law. So those are the main bills I will talk to you about. We also have the Citizenship for Essential Workers. This is the one from the House of Representatives. That's HR 1909. Same thing. There's really nothing much going on yet. And there's other bills I want to bring to your attention. And this is just for you to know that they exist. This is for you to know that we have those pending in the House. And this, we have the Ban Birth Tourism Act. is S17, which was introduced by a Republican. There's also a Birthright Citizenship Act, HR 140, also introduced by a Republican. And there is a Senate Resolution 71, and this is for aliens who are convicted of drunk driving. You're now saying that if this is just introduced, we don't know the fate of these bills, we don't know if they will be passed or what the outcome will be, but it's just for you to be aware so that you don't get into any trouble of any sort. So this is, they're saying that if you are convicted of drunk driving, it means that you may qualify, you may become a threat to invest and might be subject to immigration enforcement. So that is it for the bills, and this is where we are with all these bills. And in summary, it means that we have long ways to go, but we are hopeful, and maybe I don't know when, but sometime. It's really important because we have a lot of people, we have a lot of interested parties, and including the president, who is spearheading this from the top. Thank you.
Thank you very much. That's interesting to know. So as the Biden administration is proposing immigration reforms to benefit immigrants, then we also have, just like you said, some bills by the Republicans that are also, anti-immigration, if you can call it that. So thank you for highlighting that. And that's for the audience to know that it cuts across both ways. Hopefully the reforms that we hope to come will come. But now talking about, so those are bills, but there are also some changes that have already, because the bills, like you said, they're still in the works. What are the significant immigration policies and practices that the Biden administration has already implemented reforms on as now? What are those kind of reforms that have already taken place? Or what have they rescinded from the past administration that has benefited immigrants now?
Well, thank you very much for that question. And actually, this is a big kudos to the Biden administration. It's really a little over 100 days, and it's just amazing to see how so much has changed. There's still a lot of work to be done, but a lot has also been changed, and we in the immigration community are very happy about that. So the first is the Muslim ban that has been rescinded. And this was where targeted Muslim countries were banned from entering the country. That has been rescinded. We also have the African ban, which targeted 7 African countries, and that has been rescinded. Now we know that with that, both the non-immigrant and immigrant visas, people from these countries are able to now apply and possibly be able to join their loved ones in the United States. We also have the public charge rule, which has been rescinded. The public charge meaning that if you, for any reason, have received public benefits, this would not deter you from obtaining immigration benefits. So that has been rescinded, and it was supported by the form I-944. We no longer use that form. So if you're applying for adjustment of status, you don't need to use or submit that form. So that is one of the changes we are seeing, and actually it's been implemented right away. We also have the citizenship questions. So now, before the Biden administration came into power, the Trump administration had expanded the citizenship questions from 100 questions to 128 questions, and you were expected to pass 10 out of the 20 questions. So now the Biden administration has reversed to what it has always been. That's the 100 questions, where you expected to pass 6 questions out of the 10 questions. So that is good. So that anxiety is no more. So you don't really have to study for 128 questions. We've also seen that the Biden administration has done a lot to streamline the process of benefits, because we had so much backlogs with the courts, with the administrative procedures. So now he's doing a lot to streamline this process. And one of the processes are where I'm sure a lot of you are seeing that, where you're receiving notices saying that you don't need to do a biometrics exam anymore, that your previous biometrics will be captured. So we're seeing a lot of that. And sometimes, and we're also seeing for maybe children who are over 21 who have applied for their petition for their parents. We're seeing in some scenarios where the interview process is dispensed with. You don't have to attend an interview. So with this makes it a lot faster and getting down to a lot of backlogs so that there's so much backlog, and this is also helping. So we're also seeing that officers in the immigration agencies are more diverse. So there's a more diverse workforce now, serving the people that they are supposed to be dealing with. We also have the non-immigrant ban. So the non-immigrant ban, non-immigrant ban targeted some, well, I would say some visa classifications like the H-1B classifications, the J visas, and some others. It targeted them, not allowing them to enter the country just because of the competitive nature, wanting to protect American workers. So what the Biden administration did was not rescinding that, it did not rescind that, but it allowed it to expire, and it expired on March 31st of 2021. So it also granted TPS to Venezuela, extended TPS to Venezuela, and I believe Burma, one of the other countries. So that's about it. And I know some more changes are we're still expecting a lot more changes. Thank you.
Thank you so much. That is good news for everybody. So I will now hand over to my co-moderator, Mr. Adekombi, to ask the next set of questions.
Okay, thank you, Dr. Badru, and thank you, Attorney Uche Mwaneri. Before we proceed further, I would like to quickly let us know that King Justice Ministry, as a group, we are a 501c3 outreach arm of the Redeemed Christian Church of God, the King's Palace, Katy, Texas. And our mission, again, one more time, is we are trying to create political reawakening among believers and people generally all over the world, provide legal and social services for our community. For more than 3 years now, we have strived to make a difference in our community and the world by providing free immigration clinics every month. So we have immigration clinic once a month. You can join us on Zoom. That information will be made available at the end, I hope, at the end of this program. And then you can also visit our website, www.kingjustice.org. There's a form there. You can fill your information. We will get that information, or reach us. There's an email available, info@kingjustice.org. And then we have monthly prison outreaches as well. We visit people who are in prison. We also have voters registration. In America, you have to be registered to vote. If you are not allowed to vote. And then also we create awareness about domestic abuse. So those are some of the things that we do. Again, for more information, visit our website, kingjustice.org, or send us an email at info@kingjustice.org, or call us 832-438-3644. Again, 832-438.
Thank you. Mr. Adekombi was telling us about the King's Justice Ministry. We'll also post that information online, and we'll also give it to you at the end of this segment.
Okay, I'm sorry for that interruption. So what we are going to go through next now is I'm going to be asking some questions from Attorney Chinedu Waneri. So the question that I have for Attorney Chinedu Waneri, again, is one of our attorneys here. Questions relating to immigration again. And one of the first questions I want to pose to him is, what are the current pathways to acquire permanent residence in the United States? Somebody who is here in the United States, what are the current pathways that somebody can become a permanent resident?
Thank you so much for organizing this wonderful program. And then is a burning issue, questions on immigration now. And of course, everyone who steps foot on US soil most likely wants to become a permanent resident, because that's where they get most of the rights before they become citizens and have the right to vote. So the pathways to become a permanent resident, or just let me use the common term, green card holder, which is what most people call it. How do I get green card? There are so many ways, but you have to know your audience and then know exactly what what suits them best. So most people, for our purpose, for our kind of audience, you have the immediate relative path, which is where your spouse or your parents or your children who are above 21 years old and are working are citizens, and then the petition for the family relative. So that means somebody who is here as a US citizen can petition for a non-citizen to become a permanent resident on the basis that he or she is my wife or my husband. A parent who is a citizen can also apply for their children. There are different categories. They separate them: children who are below 21, and children who are above 21, children who are married and above 21, and children who are not married but also above 21. These are different categories. But ultimately, petition can, lie for them. Then you have children whose parents are not citizens, but they are now 21 years old and they are working. So it's very important to add that they are 21 years old plus working. So that means if they are 21 years old and are in school, they are not qualified to petition for their parents. But if they are 21 years old and are working, then they can file for their parents who are non-citizens to acquire permanent resident status in the United States. So that's one option. But generally, you see, all these people are related by virtue of family. So we call them either family petitions or more official language, immediate relatives. The second category is through employment. Your employer can file for you. If you are a computer guru in Nigeria, in Africa, in China, or India, an employer here can identify you and apply for you. An employer here can also apply for a non-citizen who is inside the United States. They can go to a university, for example, and pick students who are graduating, but they are on students' visa, and then employ them and file for them. Nurses too, people who are here on students' visa and they study nursing, most of the time they acquire employment here, and then the employer will go ahead and file for them to get green card. So that category, we call it by employment. But the subcategory, which is a little bit narrow and not used a lot, is self-employment. A lot of people don't know that they can self-employ themselves. That means they start their own company and then apply for green card based on starting their own company. So somebody can graduate from university or technical school here and maybe start a formidable mechanic workshop. He starts flourishing, and he can, based on that, apply for himself to acquire green card. So he's not being sponsored by any third-party employer. He's kind of forming his own company, employing himself, and applying for green card based on that. It's a narrow area. Most people are not aware of that, but it's good to let people know that there is a track. There's a pathway too. Um, to acquire green card using that means or method. Then you have the asylum and the refugees. Asylum and the refugee, they are related. The only difference is if you are running for safety of your life and you are outside the United States and you are in a refugee camp, and the United Nations come to that refugee camp and process the individual and say, yeah, this person is qualified to be admitted as a refugee in any foreign country. So let me use Kenya for example. A lot of Somalis ran to Kenya at the peak of Somali civil war. The United Nations came there, processed them, and then sent most of them to United States, United Kingdom, France, Germany. So they are being sent out, they are coming in as refugees. So when they're coming into the United States, once they step foot on US soil, they acquire refugee status. And they don't need any other processing. And if they stay on it for like 1 year, they can go ahead and apply for green card. Then you have people who found their own way into the United States. So they may have come here as visitors, they may have crossed the border, they may have come, on on the wings of the eagle, so to say. Once they stay put on US soil and tell the border authorities that I am running away from her, then they can apply for asylum. If they get granted or get approved for asylum status, if they stay on it for 1 year, they can also apply to become permanent residents or green card holders. Then we have the other narrow issue, which is victims of crime. So if you are a victim of crime, so you are in the United States, you don't have papers, and you are a victim of crime, one is you're a victim of crime. The second thing is you can identify, or another person can identify the person that committed the crime against you. So if those two things happen and you complain to the police and help the police to prosecute that person, based on that, you can also get approved upon application for green card. We also have closely related to victims of crime are informants. So you work in a hotel, you are a janitor, you are a cleaner, but you don't have your papers, and you see that somebody is using underage girls for sex trafficking. You monitor them, you complain to law enforcement, the person gets arrested, and based on your testimony, gets convicted. You can apply for green card as an informant. So there are other categories of informants too, but all of them can eventually acquire green card status based on that. Then for our purposes, you have the extraordinary ability. Extraordinary ability category involve people who are either highly educated or highly talented. So the highly educated might be the professors or people who have made discoveries, and then they can apply to immigration and said, I have developed this, I have invented this, I have published these articles in world-renowned magazines or um, journals. Based on that, they can be granted green card. The other group is the talented people who are like musicians. They can be footballers. They can, based on that skill that they have, if they are in the US or even outside the US, apply to come in as immigrants, or they want to acquire US green card and they can have it. We also have slightly people who can apply based on investment. So it fluctuates. It used to be 500,000 minimum. Now they're moving it to 1 million. We won't be surprised if it gets back to 500,000 minimum investment. But based on those kind of investments in the US, one can also become a permanent resident. Thank you.
Thank you, sir. Thank you very much for that explanation. I think I've learned a lot from your explanation. One of the questions that I want to ask you before we go on a break is that can you please tell us briefly about the R visas? What are they? I'm sure a lot of people have questions about R visa. What are the R visas?
Yes, thank you so much. The R visas are the religious visas. And just to give a comprehensive overview, a church overseas can apply to the United States to be allowed to register as a church and been granted that status. So all of them are kind of religious application. So now the church is applying, but most of the time what we see is the church is applying and at the same time applying for a pastor. Because when they start the church, there's going to be a pastor who will be shepherding the church. So you have these two applications running side by side. That is one category of R visa. The second category is where the church is already here. They're already registered in the US. They have some pastors here, but they want to have immigration grant religious status or visa as a pastor of their church, by immigration. They want that member of their church to become a pastor recognized by US immigration. That category of recognition is called religious visa. Now, let me go to the first explanation, which is the church is coming in and at the same time with a pastor. That one is doable, but it's a little bit tough. If anybody is going to do that, make sure that you use an attorney to do it because the standard now is very, very high. The second one, let's now go to the second track, which is we have a church and we want one of our members to become a pastor. The first thing immigration looks out for is, has this person been a member of your church for the past 2 years? Now, membership doesn't mean that he must have been a member of the church here in the US for 2 years. If it's proven that he's a member of the church outside the United States for 2 years, that is okay. When they do that application, the good thing is they can apply, if they are married, they can apply along with their spouse and children who are below 21. So the primary applicant gets what we call R01 status. The dependents of the primary applicant will become R2 dependents. And then they go through the application process. If it is granted by immigration, they can be on R01 for a maximum of 60 months. On certain occasions, it can be extended to 72 months. But they don't grant the 60 months all at once. They can give it for 7 months. They can give it for 24 months or 30 months, depending on, they have a discretion to do that. But one thing is, keep track of how many months they gave you. If they gave you, for example, initially 12 months, that means you have to apply to renew and you have 48 months left, to apply for, extension to be in that category. But the common question which most people ask is, must I be in R01 for the entire 60 months before I can acquire green card? The answer is no. But the pitfall, and this is what people must look out for, is if you're an R01 and you want to get green card, now immigration wants you to be employed for at least 24 months on R01. Most people know this, they will tend to know this, but the thing that trips a lot of applicants is they get R01 as part-time pastors or part-time church ministers. That means they're working for 20 hours or less or less than 40 hours. But the immigration rule is you have to be on it for 2 years on full-time status. So if you are on R01 and you're planning to be sponsored to become a green card holder based on your R01 status, make sure that even if you started as a part-timer, that along the line, you've changed to become a full-time employee of the church. Okay. And then the R01 cannot work outside the church. They can work for 2 religious organizations, but they have to ask for permission from immigration to work for 2 religious organizations. Otherwise, they are required to work for the religious organization that sponsored them for R01.
Thank you, sir. Thank you very much. I have a follow-up question on R01, but we are going to take a 5-minute break so that people can get water, get something to relax, and then come back. Just 5 minutes. For those who are joining us, we are glad you are here. Please, we're going to be back by 11:06. For those watching us from Nigeria, that will be about 5:06. So, or watching us from Europe, from America, from Asia. So, here with us, 5 minutes break. Thank you.
The King's Justice Ministry is a not-for-profit outreach arm of the Redeemed Christian Church of God, the King's Palace, Katy, Texas, with the mission to create political reawakening and to provide legal and social services to our community in several areas, especially immigration services. As citizens yearn for good governance, law, and justice in the world today, the King's Justice Ministry has, in the past 4 years, strove to create political reawakening, connect with the defenseless, and support the vulnerable in our society. We specialize in these 4 areas: immigration services, governance and politics, domestic abuse, and prison outreach. We strive to make a difference in our community through several outreach programs, including our monthly immigration clinic, prison outreaches, voter registration awareness and engagement, and domestic abuse awareness. To find out more about the King's Justice Ministry, please visit www.kingsjustice.org. The Law Office of Ope Badaru is a full-service immigration law firm based in Houston, Texas. We provide a full range of immigration services, from temporary visa applications to permanent residency and citizenship. All our services are structured and tailored to meet your unique needs and take the stress out of the immigration process. For more information, please call 346-888-7091 or visit our website at www.opebadaraulaw.com or email at info@opebadaraulaw.com. Are you thinking of where to spend your vacation this summer? Join us for our annual children's vacation. This year, we are going to Orlando, Florida. Experience the thrills, the fun, the rides, the feasts, and much more. Some of the excitement includes visits to Disney World, SeaWorld, Aquatica, the Holy Land Experience, the Florida Science Museum, and the zoo. Dates for this amazing vacation are July 11th through the 17th, 2021. Our lodgings are at the exquisite Westgate Vacation Villa. Individual, family, and group registrations are available. If you'd like to sponsor a child who may not have access to a vacation this summer, you can do so. For more information, please call 832-338-7460. Again, 832-338-7460. This event promises to be one of the best vacations ever.
Effective and efficient leadership is undoubtedly one of the greatest areas of need in church today, and that's where we come in. The Redeemer's Leadership Institute has been developing Christian leaders capable of taking the church forward into the 21st century since 2008. We specialize in these 6 areas: the training of pastors for new and or smaller parishes, the training of leaders to train other leaders, the training of leaders to adapt to a changing world, the training of potential leaders in order to equip them for leadership roles, the training of new pastors on their societal, governmental, and business issues impacting their church activities, the training of leaders to have a balanced spiritual and secular pursuit. Our staff include highly qualified and experienced teachers and trainers who are passionate about building up the next generation. This is all towards a goal, that the man of God may be perfect, thoroughly furnished unto all good works. 2 Timothy chapter 3, verse 17. Please visit our website, www.redeemersleadershipinstitute.org, to register for your next class.
All right. Thank you. Welcome back. Hope you had a short break and you're able to get some water. So we are going to continue from where we stopped and took a break. Attorney Chinedu one area and Attorney Uche one area and Attorney Busayo one area. Attorney Busayo Facility. Thank you so much for your time and then all the knowledge you are sharing with us. I'm sure a lot of people have been blessed, as I am. So Attorney Chinedu Waneri, I want to follow up with you on the last question. And the question we were on the last time was on R visa. And the follow-up question is, can you explain how to apply for R1 and R2 visas and how long does it take? And then what's the difference between this visa and the green card?
So the R1 and R2, which is for the dependents, you can do an application at the same time and you can do them separately, but one must come before the other. You must have the R1 before the R2. If there is no R1, then there won't be R2. You have to have the principal applicant before you can have the dependents who will climb on the back of the principal applicant, to get status. It's very risky now to tell anyone that it takes this length of time. The risk you are running is you may have given a wrong estimate. You call on immigration, they will tell you, oh, we are working on it. Now even before COVID came, they weren't following their timelines. Now with COVID, they now have a better reason to tell you that COVID has slowed them down, which is actually true, because a lot of them are now working from home. Remember the immigration office, so many years ago, they split them into departments. So a particular area gets clustered in a particular state, and they specialize in just doing R1. Another one specializes in doing naturalization. And they do this all over the world. So in fairness to them, they are heavily overworked, even though they employ the best staff that they can find in the market. So that the reality is the timeline is lacking. But on the average, when you apply for R1, you should allow anywhere from 6 months to 1 year, to get it. But that is based on the fact that you give them everything that they need. If you don't give them everything that they need, they won't deny it, but they keep asking you, send us additional information. And anytime they ask you to, which we call request for evidence, anytime they request for additional evidence, it takes your application back by about 3 to 4 months before it gets back on track. So you can see some people who apply for R1, they get it after about 15 months, almost 2 years. And others who, within 6 months, less than a year, they have gotten their R1. But in practice, those that use professional services, they stand a chance of filing a complete application from the word go at the beginning. And once you do that, that hastens the processing, that shortens the processing time. Because immigration will review it and say, well, we have everything that we need, and we move it to the next one. Now, the difference between the RO visa and the religious visa is you come into the US either as a visitor and apply to switch to RO visa, and it gets granted. That's your first step. Or you come in from overseas with an RO1 or RO2 visa, you apply through the embassy in your country, gets granted, you land in the US, you're on RO visa. Once you're here on RO visa, then the timeline for you to become a green card holder starts running, for you to become a permanent resident starts running. And that is where I say, from the time you get your RO1, you need to have worked on RO1 status for 24 months on a full-time basis. So if you work for 24 months, but you are part-time, most people overlook that. If you apply, then you may not likely have your application for green card approved. Okay, but in between, once you apply for green card, your family and yourself will be given work authorization, employment authorization to start working before the green card application is approved. Mind you, when you are only on RO1 and prior to applying for green card, only the RO1, the principal applicant, the pastor, the church worker, that is the only person authorized to work in the US in that church or ministry. His family members, his spouse, his or her spouse or children who are on RO2 can go to school, but they cannot work. But when the principal applicant applies for green card, all the dependents join him also in applying for green card. Now, when they apply for green card, before they get green card, if everything is okay, immigration will first of all give them employment authorization, or what we popularly call work permit. Once they get work permit, the family members, those on RO2, can work anywhere they want to. But the RO1, even though he has work permit, is still required to only work for the church. So it's good to make that distinction. Most of the time, because he has employment authorization, he can go out anywhere to find employment, just as his or her spouse are doing, and children who can work. The RO1 holder legally is not authorized to work outside the church or the religious organization. And also, people, when we talk about RO1, everybody thinks religious visa is for pastors and bishops and priests. No, if you are a musician, you are a church worker, you can also be on RO1. You help the choristers, or you teach some church ministry. The church can sponsor you. So is either a church minister or a church worker. Each of them sponsored by their parent church can be on RO1 visa.
Thank you very much, sir, for the question. So I would like to ask you my final question before I go to Tony Uche. My final question for you is, what are some of in what instance can somebody who is a green card holder, that person can lose their green card or green card be revoked? What are some of these circumstances that can lead to that?
Well, you can surrender your green card. You can say, I'm tired of being a permanent resident of the United States. I want to surrender it. That is rarely done, but it's good to let people know that they have the right to surrender it. So they relinquish their permanent resident status. The other one is people lose it at times unconsciously. Remember, green card means I want to become a permanent resident. So you get the green card, and then you travel overseas, and you stay there for more than 1 year. Immigration takes it to be that you plan or you have relinquished your intent to become a permanent resident. So if you have green card and you don't want to lose it by, you know, unknowingly, if you plan to go outside the country, stay for more than 1 year, make sure that you apply to immigration upfront and say, look, I'm traveling overseas for XYZ reasons. It's likely I may not be back within 1 year. Then, if you do that and they grant it, you can now travel. So you can stay away for up to 2 years. That permission doesn't exceed 2 years, but you can renew it. Okay. But there is still, it's good quick. I need to quickly add that if you get that, the time for you to become a citizen gets prolonged. Okay, so you have to know that when you're staying away that long, even though you're authorized in advance, it may affect the time, you know, you need to accumulate to qualify to become a citizen. Now, the most common ground for losing green card is when someone commits a serious crime. You commit a felony and the person gets convicted. If it falls within the group of offenses that the law says, if you commit them, you will lose your green card, number one, and will take you outside the country, then that will happen. But for purposes of this symposium, in practice, everybody is looking at the offense we call felonies, which are the serious offenses. But there are tiny offenses that can send a green card holder packing. If you win lottery, for example, and you come into the US with your green card, and within that 5 years, you commit a crime of moral turpitude, just one, that person may lose the green card and be asked to leave the US. And the crimes of moral turpitude, the legal authorities explain what it is differently. But to an audience like this, a crime of moral turpitude is an offense that you don't commit by mistake. And number two, when you commit it, you deprive an individual, a company, or the US government of their ownership in what, you know, of a property. So I go to Walmart and I don't pay for a lipstick or even a baseball cap worth $5, and I get caught on my way out. So that is theft. But the value of what was stolen is just $5. But in the eyes of immigration, that is a crime of moral turpitude. Because one is a crime of a dirty mind. I plan to go to Walmart to deprive them of that $5 lipstick or $5 baseball cap. And if I did succeed, Walmart as a company would have lost ownership of that item. So these are things that are called crimes of moral turpitude. It's a crime of a dirty mind. Let's compare. Somebody is driving and has an accident and kills someone and he is at fault and he is on green card. He may not be asked to leave. And you say, I stole only $5. They are sending me away. And this guy killed someone. They are not sending him away. That is the difference. So people have to be very, very careful about what can trigger their loss of green card. Now, if you are on green card, you come into the US and you got green card right away and you stay there for more than 5 years, then you need 2 crimes of moral turpitude. So they don't need to be serious felonies, but they are crimes of moral turpitude. 2 of them can add up and they start removal proceedings. Or you just commit 1 crime, which is a felony. So that one is, can also cause someone to lose his or her green card. Felony is not always violent crime. If you dupe the US government up to $10,000, that is a felony.
Thank you very much. Thank you for shedding light on those questions. If you have any question, we have received a lot already from YouTube, Facebook. Please keep them coming. If we are not able to take all your questions today, again, be reminded that our immigration clinic holds every month. So the next one is going to be 5th of June, by the grace of God, 5th of June. The Zoom link will be made available so they can join us. That way, what we do via Zoom is we put you with an attorney for your privacy, is one-on-one. So your questions can be asked directly. So you can join us June 5th, 2021. My next question, I'm still on the question on immigration, but this question will go to Attorney Uche Waneri now. I think the question that I have for Attorney Uche Waneri is, what are the, right now, some of the issues that we have right now is, please, can you shed light on some of the asylum, both affirmative and defensive? And then what are some of the drawbacks of frivolous asylum petitions?
Well, thank you for that question. And I know that a lot has been said about going on about asylum. I will start with that, the distinction between affirmative and defensive asylum. So affirmative asylum or affirmative asylum is really when you, on your own volition, apply for asylum. And this asylum is, of course, we know that with asylum, you are fleeing from persecution from your country. And there are 5 protective grounds that you have to plug into, even if you're fleeing from persecution. You must be fleeing from persecution based on those 5 protective grounds. And those are your religion, your gender, your political opinion, national interest. All of those are reasons why you are persecuting, why you are fleeing from your country. So when you are applying for the affirmative asylum, you are applying on your own. You came into the country, maybe on a regular visa, and now you are changing your status, or you feel that you can't return to your country because of future persecution or maybe because of past persecution, then you are applying on your own. And usually the interview is before an asylum officer. Mm-hmm. So after applying, you ought to have applied within 1 year, even though the rule has changed now that immigration has to inform you about when you are supposed to apply. So even if you don't meet the 1 year deadline, there's a new ruling from the court saying that you're supposed to receive that notification. So after applying, you are now scheduled for an interview before an asylum officer, and the asylum officer there will make a credible fear hearing, and based on your interview, may grant you asylum right away. If the asylum officer does not believe your story or feels that there's still something lacking, he or she may now refer you to the immigration court. So now when you go to the immigration court, if your case is referred to the immigration court, it means you have now been put in removal proceedings. And in removal proceedings, there are charges. It's just like a criminal charge. You have the complaint and there are charges. So with that, you are supposed to enter a plea, pleading whether you are accepting the charges. And if you are accepting the charges, you're given now an opportunity to provide the judge with any reliefs you want to apply for, and that's when asylum comes in. So it's now as a defense, it's now a defensive asylum issue. And in some instances, it might be just a referral from the asylum officer, where you don't even have to plead to any of these allegations. So that's really the main difference between an affirmative asylum and a defensive asylum. One is before the asylum officer and the other is before the immigration court. And the one before the immigration court, you have to go through a trial, and a decision is made where a removal order may or may not be entered, and the asylum may be approved or granted.
Thank you very much.
You're
So
welcome.
I will take these two questions and put them to as one because of our time. What options are available for people in removal proceeding? For example, somebody who is in removal proceeding, and the next question is, what about somebody who has been deported and would like to return to the US? What options do they have?
So the first option I would say, if you are in any removal proceedings, this is, you don't have a choice, you have to go to court. And this is a time to hire an attorney to represent you in court. So it usually comes with a notice to appear. You're going to receive a notice to appear, and that's where you're going to find the allegations which you are supposed to admit to. If you enter the country and you overstayed, and you're going to find all those listed. So you have to, the options are you have to attend court, you have to attend all your hearings, you have to keep the immigration court apprised of your address. Anytime you change, you have to let the immigration court know that. You don't want a judgment entered in absentia. That's why you have to attend all your immigration court hearings. So that, I believe that's what you have to do for when you are put in removal proceedings. And based on what you are charged with, sometimes you might be eligible for cancellation of removal, for asylum. It just depends on what the charge is. So I would suggest that when you receive such notice, try to engage the services of an attorney.
Thank you very much. Thank you. So one more question that I have for you before we go to questions from our audiences, live audience, is can you quickly explain to us or enlighten us about the consular processing? Somebody who is watching us right now in Europe, Africa, or Asia, what is that? What does that mean? What should people be mindful of when they are applying for visas in the US, consular processing?
So consular processing, thanks for that question. Consular processing really means you're applying for your visa, immigrant or non-immigrant visa from outside the United States. So it could be from your own embassy, from whichever country that's called the post or embassy. So what that entails is, it's, like I said, it's a non-immigrant or immigrant petition. And usually the beneficiary is the one outside, is the person outside. So you would have either a family member applying for you, petitioning for you, or it could be an employer, or you're coming in by investment visa, or any of those classifications. But what it means is that you're going to apply using the online system. And it's proper that you know the classification. You should know what you're applying for. If you're coming for a visa, it's a non-immigrant visa, and you have to fill out that application. If you are petitioning for non-immigrant visa, then there's a process. That one starts from the United States, and it goes through 3 departments: the United States Citizenship and Immigration Services, you have the National Visa Center, and of course you have the embassy. So those, it depends on what you will be applying for. But the main issue you have to know is that you are applying for the right classification, and you are answering those questions thoroughly. When you are doing that, filling your application online, make sure you have your passport. I mean, things people overlook. Your name may be inconsistent. Your name may be Dayo in your passport, and then in your birth certificate is Oladayo. Pay attention to those details and make sure that everything is consistent. Your birth certificate should match what you have on your passport. And all those, with all that information, you're able to fill out the forms online. And with the forms online, remember that there's a new feature that has been introduced, and that's social media. You're going to be asked about your social media platform. So all this information, make sure you're answering the questions completely, truthfully, and honestly, and I would say, because, and one more thing I'm going to say about that is when there is a renewal, don't just renew without updating your information or say they already have my information. Take that time, review your information, update the information that is necessary, because that information, that is the inception of you getting into the immigration system. Any information you put into the system stays there. And even if you are applying for citizenship, they have records of all that information. So you want to be consistent at all times and truthful.
Thank you very much for that enlightenment. Now, I will start with questions from YouTube, Facebook. We have some questions. Please keep them coming. Again, if we are unable to take your questions today, our attorneys will be available by the grace of God during our immigration clinic. So the first question that I have here that was posted is, what are available options to receive a work permit for an F1 student who has completed post-completion OPT in another degree, then went ahead to earn a nursing degree? So what are options available for that kind of person?
So this person, can you repeat that question, please?
Okay, the question is, this person has completed, this person was granted a permit as an F1 student and has completed a post-OPT, OPT in another degree. Then the person went ahead and earned a nursing degree. So the question is, the person is not unable to renew her visa. So what options are available for the person?
Can I comment on it?
Yes, go ahead, sir.
Yeah, because I think it falls within the area I was discussing. So basically, what this question is seeking to know is, can I do OPT twice? Okay, if you just frame it in a very simplified way. So because what it's saying is, well, I'm an F1 student. I have graduated in 1 degree and I did an OPT. And now I went ahead and earned a nursing degree. Now it's very important to say that it is a nursing degree. So she may have, or he may have obtained a bachelor's degree and now went on to obtain a master's degree in nursing. Most of the time is a higher degree. He or she may be qualified to have another OPT. Now, if he just did a first degree and went and did a certificate course, there won't be an OPT availability. Okay, so so that's essentially, even though the person used the word work permit, so it's, what options to receive, available options to receive a work permit for an F1 student who has completed OPT in another degree, they went ahead to earn a nursing degree. Yes, the option 1 is quietly go and ask for your OPT. You're entitled to it. It's a second degree, and of course, most likely a higher degree. And then number 2 is, the other way, the question is technically asking, what form of employment can I get? So now you can do an H-1B after your second degree. H-1 visa is people who have higher degrees and are teaching. But if you want to get work authorization, get employment authorized, H-1 is split into 2. If you're going to use the F1 track, the H-1B track. If the employer is a private company, they have to wait till April 1 to apply for you. But if the employer is a non-profit organization attached to an academic institution, or only an academic institution, they are allowed to hire foreign nationals all year round. They don't need to wait till April 1 when they can apply. So if you're graduating and an academic institution includes even something like a high school, people think that it must be only a university. No. So if you talk to a high school, or a chartered school or community college or university, and they're willing to hire you, you can get work authorization right away. They have to sponsor you through H1. They don't have to wait. Okay, or maybe a hospital, but it must be attached to a higher institution. So if I have a private hospital, I may not give you H1 all year round. If I have a hospital attached to University of Minnesota, their teaching hospital, the university is already authorized to hire all year round. The hospital attached to them can also do the same.
Okay, thank you very much, sir, for that answer. So I will take this question again from our live audience. This person applied for employment authorization document with his or her spouse in March. One of them got their application approved along with the children, and the other wasn't. Because this person is worried, the person called USCIS, and as a result got a letter stating that the employment authorization document was approved, but the online account still remained the same. The status did not change. So in a follow-up, USCIS informed this person that the application was denied. So the question is, what should this person do? That's the question.
Okay, I'm going to take that question, and what I would say is this is a forum and for, I guess, the public. So I don't expect that we're going to be giving legal advice. So that question, there's a lot of details, and really this is not going to be a forum to discuss the details of that response, because a lot has to be known before answering that question. So I would advise whoever that caller is, if you're able to follow up with one of the attorneys, you're going to get a more productive response to your question than answering it on a public forum. But if you are just asking, okay, about the efforts you have done, yes, it is not uncommon. You're going to find such issues come up. And when those come up, it's really, immigration is a huge mess now. It's a huge mess. So I would say that you should follow up. I would advise that or recommend that you follow up with one of the attorneys to be able to discuss what your options are regarding your particular issue. Thank you.
Thank you. Dr. Badru.
Thank you, Mr. Adekombi. This has been very enlightening. Even for me as an attorney, it's been very eye-opening about the nuances. And I think what we need to reiterate to the audience is that when it comes to immigration, it can be complex, even though it appears simple. It is always good to start with your best foot, to consult attorneys. We have immigration clinics, and the attorneys here do have their own services that they will also be able to consult with you on specific questions. So I want to go back to Attorney Busayo Fashidi. I just have a couple of questions that I just want you to speak to, and then we can go back to the general questions for the audience. So one of the things that we already know is that there are many people who are out of status. They may have come in legally by some ways or the other. And I want us to just address this, Attorney Fashidi. Are there any options for people who are out of status? And also, what are the implications of being out of status for some people who are already in status and are considering, not keeping? What are the implications of being out of status? And if they do fall out of status, is there anything that is like something that they can access with regards to benefit?
Thank you for that question. The options, when Attorney Chinedu was talking, he spoke at length about the ways to obtain the immigration application green card. So one of the things about being out of status is that it limits one's options considerably. So if you enter the United States, let's say you come in on a visa, the CBP or the people that you meet at the airport who welcome you into the United States or who allow you into the United States, they determine the length of your stay here in the United States. So usually they grant about 6 months. So let's say you enter the United States and you're asked to remain in the US for the 6 months. During that time, you are in valid status. But the minute you don't leave at the required time, then you fall out of status. Another way people fall out of status is, let's assume you're here, you're a student, and you do not go to school as you should. Then you fall out of status. Or in any way you violate the terms of your immigrant, maybe your immigrant visa, then you fall out of status. So, or sorry, your non-immigrant visa. That is when you fall out of status. So at that point, it becomes very limited. The options of getting back into status becomes very, very limited. The only people that are kind of granted an exception are those who are categorized as immediate relative of US citizens. These are spouses of US citizens, parents of US citizens, and children of US citizens under the age of 21. For those ones, even if they fall out of status, they're still able to adjust their status within the United States. For every other person, you may have to leave the United States for you to gain another valid status, except for probably in removal proceedings, there's some relief such as cancellation of removal, that you can take advantage of. But generally speaking, if you're out of status, it's going to be difficult to get back in status. One thing I want to really talk about again is based on practice, is for people who are preference categories. These are those who they are not immediate relatives. Any other person will be considered a preference categories. So for example, children of US citizens over the age of 21, there'll be preference categories. The spouses of green card holders, they're considered preference categories. So for these preference categories, they have to remain in valid status for them to adjust status. And it doesn't even affect, let's assume you're trying to change from one non-immigrant status, you came in on a visitor's visa, you want to change to a student visa, you have to be in valid status for you to change. If you're not, the only option will be for you to go outside the country to obtain the visa. And for people, maybe your sibling, you're here on a temporary visa, and your sibling petitioned for you, your sibling is a US citizen that petitioned for you, you have to remain in valid status for you to take advantage of that application. So you can't just, because your sibling filed for you, you can't just think that you shouldn't maintain your current status. You have to remain in that current status for you to be able to take advantage of the application. And that said, for preference categories, the Department of State, they issue what is called the visa bulletin. I would advise anyone, you can Google visa bulletin, and they release it every month. So they inform you of the type of petitions, or the petitions that the petitions that they are currently processing. So on there, you see the different categories that are there, especially the preference categories that are there. Then you will see the priority date. Priority date is kind of similar to your tag on the line or your number on the line. So anytime you file an application with the USCIS, they give you a priority date. That priority date means that was the day that it was received. So the USCIS processes most of these petitions on a first come, first served basis. So the priority date informs you of the type of the current applications or petitions based on categories, or that they are currently processing. So let's assume your priority date says February 12, let's say 1996. And if you go on the visa bulletin, and your category is maybe sibling of a US citizen, and they are currently processing people, they'll put the date on there. So anyone whose priority date is at that time, the February 12, 1996, if that is what we have on the visa bulletin, those that are there, or those that maybe theirs were prior to that date, they are able to apply to either adjust status or consular process, depending on the case.
Thank you very much. Just a quick follow-up on that when you talk about adjustment of status. So in what instances are people who are adjusting their status are able to work? What kind of circumstances would allow them to be able to work while the adjustment of status processing is going on?
Most applications to adjust status allows you to work. So if you're applying to adjust status means that you're within the United States and you're trying to obtain your green card. So if you're able to file that application, which is usually on the form I-485, based on, and it's not a standalone form. The form has to stand on a different application. So if you're able to adjust based on the foundational petition or application, you are eligible to work at that time. So you can file for, there's a category for those who are pending adjustment of status application. So you're able to file for your work authorization while the application is pending.
Thank you very much. This question particularly goes to Attorney Uche Nwaneri, who had spoken earlier about the reforms. So we had a question from the audience that, what is the fate of asylum seekers in all this reform? Is there anything, any provision in any of those legislation that you mentioned that talks about asylum seekers?
Well, not specifically for asylum seekers when you're talking about the reforms. When you're talking about reforms, we're going to see changes with the processes. And what I would say is, based on the previous administration, from Trump administration, we had very low approval ratings for asylum. It was a 30% approval for asylum cases. But with the Biden administration, we are now going to have a much higher approval rating, and not just the approvals, but we're going to have a better treatment, because with the Trump administration, we did not have, there were so many types of intervening motions that we're supposed to have when it comes to asylum, which we did not have. We're just having mostly denials. But this time, judges are now more willing to listen to what the attorneys are saying and being able to advocate for their clients. So what I would say at most with the reform is maybe a more humane treatment and not just prejudging. And I guess the asylum officers will have more power to actually approve petitions, because what they were doing during the Trump administration was really referring cases mostly to the immigration court, which is already backlogged. So this time, I'm sure that the asylum officers might be able to actually, after having a credible, fair hearing, might be able to approve asylums without going to the immigration court.
Thank you. Thank you very much. I have one last question from the audience member to Attorney Chinedu Nwaneri. You had spoken to us about the pathways to getting a green card or permanent residence. So someone wanted to know, can one apply concurrently for two different pathways to get a green card? And if so, in what cases?
Well, in practice, yes. Yes, we've seen people that, but this is always case specific. Can I marry two people at the same time and they petition for me? That's no. Can I have a petition by my parent, which is an immigrant petition, but it may take like 4 or 5 years or more, it's still pending. Can I have that pending? And maybe along the line, I get married and my spouse petitions for me? Yes. That is, so it's case specific. But generally, you can do that. But in some area, just like the little example I gave, it's not possible to do that.
Thank you. Thank you very much, sir. I will hand over to Mr. Adekombi if there are any more questions from the audience I would like to address.
Thank you. I think one of the questions that we have from the audience, please, if you have questions, keep sending them in. One of the questions that we have is, what is, the question says that, looking at the current United States reform, what if someone is in the US studying and the person is, the question, the way I'm trying to reframe the way the person has a question. The school refused to file for the person to become a green card holder. And because the person maybe is an engineer and very smart, can the person apply for himself or herself?
Okay. Well, you have to graduate from school, first of all. The school doesn't really apply for you to get green card. But what the school can do for you is, if you have spent at least 1 academic year as a foreign student, as an international student, you can apply for work authorization. We call it based on hardship, okay? And the hardship could be different reasons. Some people, the currency in their home country was 10 units to $1. Now it's about 200 units to $1. That can affect them. Maybe their sponsor has lost his or her job, or there is death in the family. So those things, based on, you can apply to the school. So you can request the school to help you apply for work authorization or an attorney to do that. But the school does not help a student to apply for green card. Now, when you are graduating from school, if you are doing engineering courses, you are allowed to be on OPT for a longer time than people who studied arts. And your OPT can be renewed. So, but you can request your school to apply for OPT for you about the time you're graduating. But the school doesn't primarily apply for you. Now, if you graduate and you're doing OPT, and for some reason you think that maybe you can't get a permanent job after your OPT, and based on the example, he's an engineer, he starts off a business of his own, he can apply for H-1B, self-sponsored H-1B.
Thank you, sir. Thank you. So I have another question, follow-up question to that. Somebody said, what are some of the issues that a green card holder, somebody who's already a green card holder, encounter when applying for citizenship? In other words, I'm already a green card holder. Now I'm planning to become a citizen. So what are some of the things that can hinder such a person or be an obstacle that people should watch out for?
Well, as we discussed earlier on, there are certain things that can stop a green card holder from acquiring a US citizenship. One is residency requirement. So generally, what people know it as well, we have to spend 5 years on green card on the average. If you acquire green card not by virtue of marriage from a US citizen, that's the only exception. The other avenues, you have to spend 5 years on green card status before you apply for citizenship. So the law requires that of that 5 years or 60 months, you must have spent half of it, at least 30 months in the US, before you can apply for naturalization. So we call that the residency requirement. So make sure that if you're traveling, keep track of how long you're spending outside the states, because that can affect you. We also see people, and this is the rare area where they spent 40 months in the US, spent less than 30 outside the US, but they are not qualified to apply for naturalization. This is a technical area. What happens is they may have left the country and spent more than 6 months or more than 1 year before coming in. You trigger a whole lot of considerations. And even though you may have spent more than 30 months, but you may be barred from applying for citizenship after the initial 5 years. You may eventually, but a new time clock will start to run. But that happens rarely, but it's good to let people know that. Now, we've also encountered people who have they will apply for naturalization and they will go and check another box. I'm applying under the 3-year rule because as a spouse of a US citizen. Meanwhile, they are applying for 5 years. And immigration will keep returning the application, and they keep wondering why they are returning it until they get frustrated, come to they enter an attorney's office, the attorney goes through the application, and we tell them that this is what you are doing wrong. And most of them will say, why didn't immigration tell me all this? They will never tell you that. they'll just tell you that you are applying under the wrong category. They won't even use the word wrong category. They use something to say that, you know, they can't approve your application or they are returning it. So people should be careful when they are doing it by themselves, you know, on how they correct their forms. And then we have the one that is GMC, good moral character. So everybody should use the General Motors vehicle GMC to remember that GMC. That one is an area that hinders a lot of green card holders from becoming citizens. Because one, if an individual is convicted of a crime, immigration wants you to be clean. That means 5 years after the commission of that crime, not after the date of conviction. Because people may commit a crime on January 1, 2020. The court doesn't pronounce them guilty till about July 2020. Immigration comes from January 1. So if you get convicted of a crime, January 1, 2020, immigration expects you not to apply for citizenship till after January 1, 2025. And they're not looking at whether the offense is felony or non-felony, or it's very serious offense or not. There are a few offenses that even though you pled guilty to them, they are so minor that immigration is required not to use it as a consideration to deny. Okay, now another area is the tax issues. And we have been seeing these cases a lot. So what most people do is they file taxes this year and they see that they are owing tax. And they say, well, next year I'm going to have tax refund. So they just keep quiet, they don't do anything. Hoping that when they get tax refund next year, IRS will use it to clear the backlog, you know, what they are owing them this year. So they'll be good. They are not spending their money, so to say. But if they apply for naturalization in between, now it becomes tricky. Owing tax does not deprive a green card holder from becoming a citizen. But owing tax and not entering into a payment arrangement deprives a green card holder from becoming a citizen. So the position of immigration is, if you owe tax, what IRS expects you to do is you call them, you said, I'm owing some tax, yes, can I enter into a payment plan? And frankly speaking, they are very liberal. $50 a month, $25, $100, $200, whatever. So long as you are paying that, you can apply for naturalization. If you have met all other criteria, you are good, you become, they'll allow you to become a citizen. But if you apply and they find out that you owe that tax and there is no payment arrangement with IRS, they'll say you don't have good moral character and they will deny. So people should look out for that.
Thank you very much, sir. Thank you very, very much for shedding light and for educating us. I will hand over now to Dr. Badaru.
Thank you so much. This has been very enlightening. It's been very informative. We hope that everybody who watched was able to leave with some very important information about immigration. On behalf of King's Justice Ministry, I would like to thank everybody who participated, who watched, who attended and sent in questions. If we were not able to answer your questions, we have our next immigration clinic. It's coming up in July 5th, 2021 at 10 a.m. The Zoom ID and information is being displayed as we speak. I also want to thank all the speakers, Attorney Chinedu Nwaneri, Attorney Uche Nwaneri, Attorney Busayo Fashidi. We thank you so much for honoring our invitation. We appreciate the fact that you were able to commit your time, your experience, and your knowledge and your expertise in this area. I would like to implore all the members of the audience, if you want one-on-one consultation, even beyond the immigration clinic, please feel free to approach these attorneys. They are well-versed in what they do. They are experts on the subject matter. And I can assure you that, you can also get information about whatever your particular instances or information about your inquiries from them. I would like to thank all the partners who helped us in putting this program together. I appreciate the technical team who are behind the scenes. All this came together because of the nights and days they have put into this program. We appreciate you. On behalf of King Justice Ministry, I also want to thank all the other partners that were mentioned before who helped us, to put this on their platform. And we hope that, we can also collaborate further. I also want to tell everybody who's watching, whatever organization that you represent, the King Justice Ministry is interdenominational. We collaborate with institutes and organizations. You can bring us to your space, and we can also have, this kind of information session. Just, get in contact with us. Our website information and our email is also displayed. Again, I want to thank everybody on behalf of King Justice Ministry. My name is Okwe Badaru. Thank you for watching. Again, our monthly clinic, at the monthly clinic, you can also have more, you can come to us and talk to the attendants one-on-one, and we can also, like I said, liaise with other organizations. Thank you again. Thank you so much. And with that, we say goodbye. Thank you.